an application in the matter of VietJet Aviation Joint Stock Company and FW Aviation London.
Good morning.
Good morning, my lady, my lords. In this matter, I appear together with my friend Mr Robin Loof on behalf of the applicant FWA. And VietJet are represented by my learned friend Lord Wolfson, King's Counsel, Stephen Thompson, King's Counsel, Erin Hitchins, Douglas Payne and Charles Robertson. Before I go a sentence further, may I please express my gratitude to the members of the court and those who are behind you for their assistance in obtaining a listing for this matter at such very short notice and at a point when we're on the very cusp of hearing the substantive appeal. I'm conscious of the fact that time is finite. May I, without any discourtesy, merely inquire about both of us whether the 2 hours we've been given includes time for the court to consider its decision?
Yes. It does.
That's the premise we were working on.
And I assume that you've therefore divided up the time between you in a sensible way.
Yes, I suggested 45 minutes each for an hour and a half, therefore. I may split mine if it's permissible between a primary submission of about 30 minutes, reserving some more for a reply. But it may well be that all that time is not needed in any event.
So, may I ask you whether we're meant to have a rolling transcript?
I was going to raise that
because
point right now.
Can I just have 1 moment? Because it's going to take 1 second.
no, it will come up there without us having to do anything with it.
Yeah.
Because it's asking for a username and password.
Well, that,
Exactly. That's very
I
right.
think there is a problem with that. It's asking
Okay.
for a username and password.
Well, let's, in any event, let's just carry on.
Thank you very much indeed. As I understood it, there was just a glitch in communication between Opus and those instructing both sides. I hope it doesn't cause you any inconvenience. I would, as I've already indicated, trim my submissions to the essential and bare minimum and no more. As to the written materials, the court has been, I hope not inappropriately, but bombarded with material. 3 skeleton arguments, 2 from us, 1 from VietJet, 2 witness statements, 1 from Mr Baker, 1 from Ms Walker, and exhibits with each, and 3 modest bundles of authorities, all for an application for a maximum of 2 hours, including judgment. This is, as you know, our application for an order which is captured in the draft, which is at page 788 in the bundle, and you've already looked at. And the relief we seek is twofold. Just pause. The last page, I think. First, that the hearing of the appeal is made conditional on VietJet paying the first instalment, $60 million odd dollars, out of a total of $181 million odd dollars in damages awarded and constituting the judgment debt, with payment for terms vary by variation, and the deadline for the first instalment being last Thursday, 4 p.m. You will understand that that is just the first of 3 equal instalments, comprising the total, to which will also attach interest and costs. Secondly, we ask the court to order that failure to pay the first judgment debt instalment, as ordered by Mr Justice Picken, results in the appeal being stayed until the condition is met, or perhaps putting it in a more nuanced way, this may suffice. Failure to provide proof of payment by Monday at 4 p.m, today at 4 p.m, means the appeal is stayed. Before I turn to my submissions, my learned friends wish to make something clear, and I'm grateful to them for providing the clarity that I know is coming. May I sit down?
Certainly.
My lady and my lords, with that rather cliffhanger ending, the position is this. An issue which I don't need, and I hope don't propose to go into, arose between the parties over the weekend. The court appreciates that there's a jurisdiction compelling reasons issue, and then there's a stifling issue. What we would propose, with the court's permission, is that so far as the jurisdiction and compelling reasons issue is concerned, the court would not take account of what we say, paragraphs 52 to 57 of our skeleton, and the evidence on which it draws, depending on where we get to on those issues, we'll make submissions and we will have a discussion at that stage. But we propose that so as to sort of avoid any issues which we may not need to get into. And that's, the parties have agreed, we hope that's a helpful way of dealing with this issue. So it's 52 to 57, my lord, and the evidence on which it relies. So, for example, in 56, it refers to a bit of Buzz Walker's evidence. And we don't anticipate that will affect the court at all in determining the jurisdiction and compelling reasons issues. But for those purposes, we invite the court not to take account of those paragraphs and the evidence on which it relies. I hope that's clear and also helpful.
Thank you.
Grateful.
I'm very grateful, my friend. May I make these 4 prefatory points before coming to the 2 parts of our submission? Firstly, on the rule, secondly, on compelling reasons. The 4 prefatory points are these. First, at the date on which permission to appeal was granted, the second trial had, as you know, not been held. The order had not been made. There was no debt, there was no breach. And forgive me articulating the blindingly obvious, but no application to attach conditionality to the appeal with respect to the order could have been articulated, let alone sought. Secondly, we recognise these truisms. Where the imposition of a condition would stifle an appeal, then as was made plain by the Supreme Court in Gold Trail and other authorities such as Harb that follow it, the condition sought, here our application for conditionality, should not be imposed. But that question imports, as was made plain in Harb, what are called the underlying realities, which is a nod towards the economic realities of the ability to borrow as well as to provide cash from one's own resources. We also recognise that a party making this sort of application must act promptly. And the points made by my learned friends in their skeleton argument about the prejudice to VietJet, should this application be granted and the appeal hearing lost, apply with as much force to us as they do to them. Thirdly, we are acutely conscious that the court will have very much in its mind the disruption that granting our application would cause to the court, the parties, other court users, and others affected by such matters beyond. And we are very, very well aware, and the Lord Justice Picken said in Banwaite, cited in learned friend's skeleton argument, penultimate paragraph. Timing could not be much worse. I can't think of us making a later application than this, say perhaps springing it on everyone in the morning. But the parties, and this is a mutual problem, are the captors of the chronology. And I'm sure you have the sequence very much in mind, sparing you the unnecessary burden of the detail, but I can take you through it if you should wish, with pleasure. I just make these 2 points. One, it is only the recency of the breach, i.e. 4 p.m. last Thursday, of the obligation to make the payment by that date that has crystallised the application. Before that, anything would have been anticipatory and therefore singly unhelpful.
Well, you made the application before that date.
But premised upon what happened if. Exactly so.
So
yes.
no reason why you couldn't have done that earlier.
Well,
I mean, you're not suggesting that you had to wait to see whether there was a default, because that isn't what you did.
No, but what we did was we put in an application that was, as you know, anticipatory.
Yeah.
But disposal of that application would have to have waited until after there had been a default or a promise of a default. And my Lord will have in mind that we've been in correspondence since the 9th of May with the other side, trying to gain confirmation that payment was coming and got no answer. But we thought we ought to let it go and see what happened. But whether the application had been made last Friday, say, or today, it's late. And so we understand very well the difficulties that flow from that.
But just to press you, I mean, could you not have made the application back in April on the basis that if there was no confirmation that payment would be made, the court should determine it promptly.
Well, it couldn't have been because it was May when the revised payment schedule was set.
That's the revised schedule, but
Yes.
you could have sought it when the original schedule was set.
But we
Of the full 181 million.
we took the view, whether rightly or wrongly, that what we would be faced with if we said, supposing after the primary order had been made, we sought immediately an application to this court for conditions to be imposed, apropos the full 181 million. In those circumstances, we would have been faced with the answer we expected of this is premature. We have until the 15th of May to make the payment at 4 p.m. You wait and see.
But what's premature about imposing a condition? Because you're obviously, you can't make an application for a condition. There's no point in making an application after the condition, time for the condition to be satisfied is passed.
No, we can seek the order after the time to satisfy it is passed, but making the application preceded, as my Lord Justice Popplewell just reminded us. So we make the application when the position is clear. So we rewind the sequence a little. Order made by the judge directly after the hand down of judgment in April. Liberty to apply to vary the time. Application made. Application heard and granted to the extent that the sum is split into 3 tranches for payment. Due on the 14th, we write on the 9th. Will you be making the payment? No answer, still no answer. And instead, we have a void. We wait to see whether we can issue an application that is anticipatory. We do that, issue the application. And then what happens is that the time then passes and they don't make the payment. So we then know for sure there's going to be a breach. And the breach crystallizes the order that we now seek. The second point I just make about the being captives of the chronology is this is styled by my learned friends in their robust skeleton argument in response as tactical skirmishing. It really is absolutely nothing whatsoever of the sort. Learned friends suggest in their skeleton is deliberately timed to cause maximum disruption, and it is cynical, and the timing speaks volumes. Well, my lady, my lords, nothing could be further from the truth. The last thing that we need either is to be engaged in this on the eve of the appeal beginning. This is nothing of the sort that learned friends seek to label it. Better or worse, it is a legitimate call to the court for its powers to be exercised to impose some conditionality on the progress of this appeal, given its historical past and its immediate position. The third matter that we wish to emphasise as a prefatory point is the nature and the scope of the relief we seek is, we submit, important.
I'm sorry, the nature
And scope of
Thank
the
you.
relief we seek. We are not presently applying under 52.18.1a for a strikeout of the appeal. Rather, we have limited ourselves to an application, as you know, under 1c for a conditional order that we will submit does not stifle VietJet's appeal in any sense. What we are asking this court to do is to mark the orders of the English High Court must be obeyed. And if a party plays fast and loose with its orders, it cannot expect the courts, in the plural, indulgence. And all that we ask VietJet do, all we ask, is that they were ordered to do. Or, if they fail to do so, they should pay a procedural price until they satisfy the condition. And fourthly, the last of my prefatory points, this is all in the context of, as Ms. Walker says in her evidence for VietJet, that VietJet is a major airline and a substantial business. We agree. It is a profitable airline that's enjoyed considerable growth, and on the 4th of February 2025, boasted on its website that it achieved record revenue in 2024. See Baker 1, bundle page 33, para 67, and page 536 516 in the exhibits. It has cash reserves of 180 million when it states its accounts as of December 2024. And whilst we note what is said in Ms Walker's evidence, I needn't go into that given what my learned friend Lord Wolfson has said this morning. We satisfy ourselves with where Mr Justice Picken came out, having become intimately acquainted with this litigation, having dealt with both trials and much of the interlocutory skirmishing, that back in the day, VietJet chose not to pay the rent then due at the date of default. And secondly, in his more recent judgment of the 1st of May, it can pay the 60 million that he directed by way of variation if it wants to.
But is that a question we've got to decide for ourselves?
It's part of the compelling reasons.
Yeah. So we can't just take it from Mr Justice Picken, can we? We'd have to look at the evidence.
Subject to what my learned friend has just said.
Yes. Can I just be clear about that?
Yes.
Because the stifling argument it involves saying that they would lose forever the ability to pursue the appeal. I quite understand that if all you're asking for is that this hearing goes off, but there's an opportunity thereafter to pay, which you say they can,
Yes.
even if they couldn't do it this afternoon, then they won't have stifled the appeal. It's a separate question as to whether they had the means to pay by the 15th of May.
Yes.
It is. And it's that latter question which Mr Justice Picken has said, yes, they did. And it's to that latter question that I'm addressing to you. The question, isn't that something we need to decide for ourselves rather than take it from Mr Justice Picken?
Well, it is when I come to compelling reasons, which I will, it is an aspect which obviously the court will want to consider. There's a world of difference between deliberacy and inability.
Well, how on earth can we do that? You gave us a reading list which didn't involve asking us to read any of that material. There is really a great deal of material. It's briefly summarised in the rival submissions in the witness statements, which, speaking for myself, I have looked at, but I haven't looked at any of the underlying material. How on earth are we to resolve that question now?
The resolution of that question is not determinative of the application, certainly not the jurisdictional point, and it is but a feature of the compelling circumstances.
Well, it's one of the features you rely upon for compelling reasons.
Yes.
Either we take it into account, in which case we've got to look at the material, or you have to accept we have to ignore it because there isn't an opportunity to do so. Which is it?
Well, my lord, I think it's difficult to answer in the abstract until we come to the detail of the submissions. We don't rank it at its highest in our list of 6 compelling reasons that we cite,
Right.
as you will see. I think that I'm not trying to avoid.
No, all right, come to it. We haven't got much time.
No.
Come to it.
Thank you very much indeed. Thank you. I'll deal with the jurisdiction point then, if I may. Our VietJet's primary argument is set out in their skeletons in paragraphs 4, 5 and 13 as amounting, in their words, to us not being entitled to make the application by reason of operation of sub-clause 3 of 5218. Paragraph 5, they say that sub-clause, sub-rule amounts to an absolute bar, and there is no exception to it. And paragraph 13, the application should be dismissed without more. And why? Because they say in paragraph 11, the rationale for the rule is that if a respondent wishes to ask the court to impose conditions upon which an appeal may be brought, it must do so at the time permission is sought and granted. They say in paragraph 14, it makes no odds that there might have been a change in circumstances between the grant of permission to appeal and the making of an application. The rule is a bar. The consequence of this absolute position that they strike being correct is this: the case management powers of this court are severely curtailed. On their thesis, this court would be precluded from managing pending appeals, even where events subsequent to the granting of permission to appeal significantly change the context in which they are brought. We submit that this submission is as surprising as it is ambitious as it is unsustainable. We note in passing that a proposition radically curtailing what would otherwise be this court's inherent jurisdiction should rest on clear authority. There isn't any such authority, and in fact, the authorities that do bear on this issue, in the context of our case, point the other way. There are two propositions which we hope to have established in our skeleton, which I hope to make good this morning. First, there's no authority requiring the court to accede to VietJet's submission. And secondly, on the contrary, there are authorities positively discouraging it. As to the first proposition, we rely on the fact that in all of the authorities before your lordships and my lady and my lords, where the court has applied 52.18.3, more often its predecessor, in fact, but that doesn't matter, the language is the same, the application either was or plainly could have been made to the judge considering permission to appeal. Because of time, I'm going to just give you the name and the point, if I may, without troubling to turn to your authority, unless you wish us to.
Just before we get to the authorities, could we just look at the wording of the rule?
Yes.
And let me understand what your submission is.
Yes.
You're not making your application under A.
Correct.
So it's not a case in which you say we strike out, but there's been a change of circumstances or other circumstances which mean we can do this under A. So, 3, party was present at the hearing at which permission was given. You were.
We were.
The party may not subsequently apply for an order that the court exercise its powers under 1C. You're seeking to ask the court to exercise its powers under 1C. So do you say that subparagraph 3 is to be qualified implicitly by some wording such as in circumstances where the application could have been made at the hearing at which the party was present?
Yes.
That's how you say C is to be interpreted?
Yes, it is. Thank you very much. The authorities. This is as to the first proposition, i.e. no authority requiring the court to accede to VietJet's submission. We rely upon the fact, as I say, that all of the authorities, and I'll turn to them, as I say, very briefly, concern circumstances which, unlike our case, point that is now, as it were, taken, could have been made, or indeed was made in some of them, to the trial judge. I'm going to use shorthand. If that's too brief, please just stop me. I know you will. Medical justice. Lord Newburger, then Master of the Rolls, when dealing with an appeal against conditions imposed by the judge granting permission. Paragraphs 5 to 6 of the judgment. Hurst Holdings, costs orders made by the trial judge, paragraphs 3 to 8. Spar Shipping, money orders made by the trial judge, paragraphs 1 and 6.
I'm sorry, it's Spar Shipping.
Paragraphs, money orders were made by the trial judge, as it were, challenge to that, paragraphs 1 and 6. SpiceJet was an application for a strikeout, but Lord Justice Phillips' statement to the effect on jurisdiction to impose conditions was therefore strictly overturned. But in any event, he gave illuminating views as to that subject, paragraphs 1 and 5. And what we take from all of those is that there is no direct authority supporting the radical curtailment of this court's jurisdiction, which VietJet contends. As to this second proposition, that in fact authorities positively discourage their interpretation, the reality appears to be that despite this sub-rule having attracted quite a lot of judicial comment, as you will have seen, from different divisions of this court, this appears to be the first opportunity that the Court of Appeal has had to expressly state, as we invite it to do, that it retains the power to manage pending appeals when circumstances arise which could not have been addressed at a permission hearing. We cite two authorities in support of the propositions that we advance. The first is Bell, and the second is contract facilities. As to Bell, it is in our skeleton argument, paragraph 7.1, our second skeleton in reply. And the passage from the judgment of Lord Justice Potter reads thus: the power in CPR 5291C is one which may, in appropriate circumstances, properly be relied on, where the condition might sought to be imposed does not involve consideration of the merits of the appeal, but is based upon some aspect of the conduct of the appellant in some other circumstances, which either had not occurred or was at any rate not available to be advanced by the respondent at the time of the grant of permission. So exactly what we have here. That's paragraph 19 in the judgment. And then perhaps even more importantly, contract facilities, where a division of this court comprising Lord Justice Waller and Lady Justice Hale, as she then was, cited at paragraph 8.2 of our reply skeleton. The Court of Appeal, said Lady Hale and Lord Justice Waller, the Court of Appeal has the power to manage its own cases. It would be very strange if CPR 52.9 prevented the Court of Appeal imposing conditions under its case management powers where circumstances during the currency of the appeal made it appropriate either to stay the appeal or stay the appeal subject to conditions, which led the court, that's paragraph 21, which led the court to conclude in paragraph 22, it seems clear that the Court of Appeal has case management powers in addition to those that it may have under CPR Part 52. Furthermore, it seems to us that the application that is now before us is an application made during the currency of an appeal, where the court is being asked to consider whether to exercise its case management powers by reference to conduct whilst the appeal is pending. That is totally different from the application before His Honour Judge Weeks. In our view, the Court of Appeal has jurisdiction to deal with this application and is not inappropriate to consider the making of the order asked, even though the respondents did not seek to impose conditions at the permission to appeal before His Honour Judge Weeks. We deduce, my lady and my lords, from that the rationale for the rule 5218.3 is that it's aimed at two vices. First, it's aimed at preventing effectively an appeal against an inter partes permission decision. You'll remember the passage in Lord Newburger's judgment in the prior case to which I've already referred to, that what a party cannot do is tuck the permission under its belt and then try and improve on it by way of, as it were, an appeal to the Court of Appeal. And the second aim, or second vice that the rule is aimed at, is ensuring that if conditionality can be brought, it should be at the point of permission being granted, hence it being itself conditional on representation at that stage. We submit that as long as 5 conditions are satisfied, an application under 5218(2) or 3 can be made. In circumstances, and these are the 5 conditions, for one, it's in circumstances where the basis for the application did not exist or was not known when the permission decision was made. Secondly, the foundation of the application has arisen during the appeal process. Thirdly, the Court of Appeal is not drawn into a debate as to the merits of the appeal as part of the application. Fourthly, the Court of Appeal is not in any way reviewing any aspect of the permission decision. And fifthly, the Court of Appeal is solely concerned with managing a case pending before it. If those 5 conditions are satisfied, we submit that there is no bar in sub-rule 3, the application being heard.
Lisette, will you repeat for me 4 and 5?
Of course. I was trying to strike a balance between speed and accuracy.
Yes, because these aren't in your skeleton, are they?
No, this is deductive from them.
So 5 was not reviewing.
Sorry, I've got 4 and 5.
Yep.
4, the Court of Appeal is not in any way reviewing any aspect of the permission decision.
Yes.
And 5th, the Court of Appeal is solely concerned with managing a case pending before it.
Thank you.
My lady, my lords, I'm conscious of the time. I'm going to move, if I may. I'll be 5 minutes, and I shall then reserve 10, as it were, for a reply if necessary.
And you'd like us to go off and look at the authorities in our own time, would you?
Well,
It's not a facetious
No.
remark. We were provided with a reading list, which didn't suggest we read particular passages in particular authorities or particular parts of the material. As you know, the court is usually fairly diligent in seeking to comply with reading lists when we're offered reading in advance. You're asking us to make a decision now, and just reading out bits of authorities which we weren't invited to look at. Speaking entirely for myself, I don't find a very satisfactory course.
My lord, may I apologise for if you find it unsatisfactory, as the court clearly does, and I do apologise for that. But can I just provide this comfort and explanation? The only two passages I read out are the only two passages that are cited from those authorities in our skeleton argument, and I gave you the reference to our reply skeleton, I hope. 7.1 and 8.2, I think. The other points that I make are entirely uncontroversial. It's obvious on the face of each decision, obvious, and they're not reductive in any way of the points I make, that the court was concerned there with a situation which could have been taken before the trial judge, which is the first list that I gave you. And that just left only the other two, and I've not troubled you with any of the other authorities at all.
We don't need to look at any of the other authorities in your submission.
Not for the purposes of determining what is the meaning of Rule 52.18.3, no.
And so where were you going next?
We're going to the compelling reasons.
Okay.
The test is set out in paragraph 6 of our first skeleton argument, where we cite from the Merchant International decision. It's, as I say, paragraph 6, page 3. And that is the leading, and I respect this, only authority we need to look at on this point, on how the court should approach whether there is a compelling reason or there are compelling reasons to impose a condition on the pursuit of an appeal. The key thing here is, as is observed in Merchant International, is that this is essentially a value judgment to be made on the particular facts of the case under consideration. And as we set out in our skeleton, there are 6 reasons, and I stress, not all of which weigh equally, which constitute jointly and severally compelling reasons when added to the foundational point that there is a plain breach of the order to pay $60 million by last Thursday by VietJet. I'm going to do this extremely shortly by reference, if I may, to our skeleton argument. I shall not step outside it, I don't think. So the 6 points that we would respectfully rank in the following order. We would start with what was the 4th point in our skeleton, which is page 7, paragraph 20. That there is here no question of any stifling of an appeal. The reasons my Lord Justice Popplewell gave earlier. Secondly, and this is the 3rd point in our skeleton, that I have very much in mind what has passed this morning, both from my learned friend Lord Wilson and then with the court. We respectfully commend to your lordships how we put it in our second skeleton argument, page 10, paragraphs 20 to 22, and conclude that Mr Justice Picken was correct when he decided that VietJet can pay if they want to. Thirdly, and this is our first point in our skeleton, page 5, paragraph 13, VietJet has no assets in the UK, and enforcement will be at best challenging, and at the very least very extended and complex. See in this regard the evidence for VietJet of Ms. Walker, paragraph 12. Fourthly, what is our second point in our skeleton? Page 6, paragraph 14. And this is an important part of the context which I emphasise, if not directly for itself in the context of compelling reasons, it's important as part of the context in which to assess them. VietJet's track record in these proceedings and its public treatment in press releases and statements for the Vietnamese stock market of the judgment under appeal, both pre and post the consequentials. Fifthly, so our sixth point in our skeleton, it's page 8, paragraph 22. The finding of egregious misconduct serves as a useful summary of the learned judge's findings, having sat through 2 long trials in this case. And though it's a label that learned friends don't like, it is a label affixed to it by the judge at trial and never departed from thereafter. Again, providing context in which to assess whether there are compelling reasons for the protection we now seek. And lastly, what was fifth in our skeleton, which is page 8, paragraph 21, the sequence imposed by the trial judge, as we say in our skeleton, and as is plain from a reading of the transcript, despite the elegance of learned friends' attempts to get around it in their skeleton, is a sequence structured to require 1/3 to be paid before this appeal was to be heard. So therefore what we seek here is consonant with the approach of the judge. As we say in our skeleton, my lords, by paraphrase, this is a paradigm case where the court should make plain to a large, well-resourced, extremely well-represented international corporation that it cannot, within the same working week, both default on its obligation to make a substantial payment, and therefore breach an order of the commercial court, and ask this court to continue to hear the lengthy appeal without there being any consequential impact of the former on the latter. In other words, those are our submissions.
Can I just be clear? Those 6 reasons or elements
Yes.
to be taken together, but ranked 1 to 6?
Yes, but ranked in the order in which I gave them.
Yes.
Yes.
And
of
so
course,
the issue that my Lord Justice Popplewell took up with you in relation to relying on what Mr Justice Picken said about can pay comes high on your list.
I didn't want to hide from that fact, no, but it's a cumulative exercise. And as I said, it's whether jointly or severally they amount to compelling circumstances when taken with the starting point of the breach as to the $60 million.
Thank you.
Thank you.
And can I, sorry, just before you sit down, is it also right that we have to decide for ourselves rather than take what Mr Justice Picken said about your factors 4 and 5? That's to say,
Yeah.
record, public statements, egregious misconduct. That's all something we've got to look into.
I don't think so, with respect. I think that the fact that what weight, my lords, my lady, my lords, will give to it, of course, is a matter uniquely and exquisitely for you and not for me. But without wishing to be impertinent about it, what I would say is that he had the opportunity to listen to evidence, hear submissions, and try 2 long cases, and also be involved in some of the other satellite litigation around contempt issues. The view he formed should be treated with respect, and I'm sure it will be by this court. And in our respectful submission, in the circumstances we find ourselves here, where what we're looking for is, are there compelling reasons to impose a condition for the non-payment of $60 million? They are points that can be taken from his judgment, and from his judgments, I should say, as being dispositive of the issue. It's impossible to expect this court, with respect, especially in the brevity of this hearing, to revisit all the minutiae that he did and come to a different view, and I don't think you're being asked to. I think our submission on this label, I think, is bizarre by my learned friends. The only thing bizarre about it is the fact they label it such. It's pretty obvious, actually. And I quite understand why other matters will be required to be considered by the court afresh, and you have the evidence of both parties on it and the skeletons of both parties on it. which is the best I think that anyone can do in these circumstances.
So far as factors 4 and 5 are concerned, we take account of what Mr Justice Picken has said about that in circumstances where we're not able ourselves to investigate whether or not he was right.
Correct. But as regards 2, just to be clear, I understand exactly why my lord and my lady then most patiently pressed me on the point. Again, Mr Justice Picken's view, having heard extensive submissions and seen the evidence, which is voluminous as to finances, formed a view, which again is a very persuasive starting point for this court to consider the viability of payment, particularly where the very issue in focus for his lordship was, can you pay 180 all at once? I'm persuaded you can't, but I'm quite sure you can pay 60 in each of these 3 tranches. And that is, at the very least, extremely persuasive in this court, our respectful submission, if not entirely necessarily dispositive in light of the subsequent evidence.
Thank you.
Thank you very much.
My lady, my lords, I'll, with your leave, be dealing with both the questions of whether there is a jurisdictional bar or some opportunity for my learned friends to read additional words into the rule and compelling reasons. If after that your ladyship and your lordship wish to deal with the question of stifling, and I'll indicate where I think the line is, I think there'll have to be a short further opportunity for my own friend Lord Wolfson and probably Mr Lissack to address you on why that is difficult. But perhaps I can just address you first on the questions of the jurisdiction and the compelling reasons arguments. The first and most important thing to note is that, as Mr Lissack candidly accepted, he has nailed his colours firmly to the 1C mast. He is only asking for an order that the court impose conditions upon which the appeal may be brought. He recognises that asking for a strikeout would be too strong a thing, and he expressly disavows any reliance on paragraph 1A. He also made it very clear in his written submissions, and I thought it was clear until he stood up, that he wasn't inviting your lordships and your ladyship to invoke your case management powers. That is a very different animal from the one which fairly and squarely he has applied under in his application notice. That being the case, in answer to a question from my Lord Justice Popplewell, he made it clear that actually what he's asking for is an implied and unwritten extension, a qualification to the bar in 5218 para 3. It is not, contrary to his repeated submission, some sort of radical curtailment that those on this side of the court are asking you to read into the rules. The rule is quite clear. You only need to read it. I will be taking you to some case law. Can I apologise to the court, first of all, that we didn't put in, and this was merely an omission because things have happened so urgently and there's been quite a lot going on over the last few days. We didn't put in a reading list, and I do apologise for that. I am going to take you, though, to some passages in the case law because in my submission, what my learned friend says is simply wrong. That there is clear case law on what this rule means, and it is an absolute art. Nobody before Mr Lissack has ever suggested that there should be some qualification, some additional words read into that rule. Everybody has said it means what it says. Can we start, please, with Millennium Friends, our authorities bundle? I don't know if your lordships and ladyship have a bundle. I don't, I'm afraid, so I'm just going to tell you where they are in the various bits of bundles which you receive. This is in orange at the bottom right-hand corner, stamped R/auth/ with a number. That's our authorities bundle. I'm going to take you first to Hurst, Holdings and Avela, case of Lord Justice Foss. Can I preface what I'm going to say by saying this? Almost all of the authorities we're about to look at are judgments of one, sometimes two, Lords and Lady Justices. Almost all are extempore. There are some exceptions to that, but almost all are extempore and recorded in transcripts which were later, no doubt, approved by the court. Just to put that into context, this is what Lord Justice Voss, as he then was, thought in Hurst. You only need to pick it up, I think, at paragraphs 47 to 49. But it is important, and I'll read it, as can be seen from part 5293, that's the predecessor in identical wording to the current rule. if the party was present at the hearing at which permission was granted, which in this case was on the 6th of May 2014 when Burst J granted permission to appeal, then that party may not subsequently apply for conditions to be applied to the permission. Thus it seems that Part 52.9 is not applicable here because of the provisions of Part 52.9.3, and therefore it was not open to the respondents to make their application in the terms that they did. Mr Mellor, counsel, did not seriously contend otherwise, at least already before me, although he pointed out, as is the case, that it's somewhat strange that a change of circumstances does not, under 52.9.3, allow the court jurisdiction to impose conditions later in the progress of the appeal. That may be an interesting point for the Rules Committee to consider, but it does not enable me to gainsay the clear provisions of Part 52.9.3, and accordingly I dismiss the application. It couldn't be clearer. Now, my learned friend Mr Lissack made lots of submissions about what he thought should be the circumstances in which the bar not be applied. He gave you, I think, 5 conditions which, as my Lord Popplewell pointed out, weren't trailed in a skeleton argument and weren't, as far as I could work out, deducible from his skeleton argument. But those conditions are something which Mr Lissack might want to bring up with the Rules Committee, but they simply aren't the law. The next case is Spa Shipping, a decision of Lord Justice Longmore, again sitting alone, extemporary decision. A submission was made by counsel in that case, similar to the one that Mr Lissack makes, that he didn't worry about this bar. Pick it up at para 6, if you may, that's page 19 of the authorities bundle. The respondents, Lord Justice Longmore said, were present at the hearing at which permission was given by Popplewell J. Therefore, on the face of it, 52.9.3 provides a bar to the court exercising its powers as asked it impose conditions on which an appeal may be brought. That indeed was the view of Voss L.J. and Hurst Holdings, which I've just read to you, and I needn't finish the rest of that paragraph. Over at 8, he refers to the paragraph I read out to you. There were then the following attempts by counsel to get round that bar. In paragraphs 10 and 11, Mr Phillips suggested that Voss L.J.'s view was per incuriam. He said, look at the case of the Society Aram, where Lord Justice Ricks said the opposite, but as Lord Justice Longmore said in paragraph 11, that case was effectively overruled by the medical justice case, which we will come to in a moment. Then counsel said, well, in that case, why don't you, Lord Justice Longmore, do what you did in Experience Hendricks, which was permit the applicant, the respondent obviously, to amend my application to rely on paragraph 1A. And in 13, you can see Mr Phillips said he would, if necessary, apply for permission to amend in the same way as being given here. But it seems to me in this case rather different. Lord Justice Longmore refused to grant that permission. At paragraph 15, Lord Justice Longmore pointed to the policy reasons underlying 52.9.3. It's to avoid, he said, the enormous potential expense and time taken up in applications of this kind. Many thousands of pounds have been spent on this application. 4 hours have had to be set aside to consider the application, which is a lot to ask of this court when its lead times are as great as they are, particularly at the moment for an interlocutory jousting. The whole point is that these considerations should be advanced to the judge at the time he's minded to grant permission to appeal, so he can have them in mind, and so an order can be made at the time when considerable sums of money and further time is not required for consideration of these matters. Now that's one. I don't think Lord Justice Longmore was intending to identify all the policy reasons behind the rule, but that is one policy reason which was relevant in that case. Then Mr Phillips tried to rely on Bell Electric, just as my learned friend does. But it is clear, again, from paragraph 18 of this authority, that that was not a case of 52.9.3. It's nothing to the point. The respondent hadn't been present when permission to appeal was granted. The case is, for present purposes, irrelevant. Then Mr Phillips, again trailing Mr Lissack's ideas, tries to rely on contract facilities, which relied on Society Aram, the case that was overturned certainly said no reliance should be given on it later by the Master of the Rolls. But that is, the contract facilities case, a question of whether the court has case management powers. And as I said at the beginning, that is not what Mr Lissack is inviting you to consider. It'd be a completely different set of considerations. It is fair to say that in contract facilities, Lord Justice Waller attempted to use the case management powers to point out that the court's powers to manage cases certainly shouldn't be curtailed. Now, that's an argument which may or may not be argued at a further point. I don't need to raise that question. It might be an interesting legal issue about whether the rules should be said to curtail this court's case management powers. One can certainly see arguments both ways. But as Mr Lisak doesn't put any application on that basis, for your purposes, you can ignore it. And then, just dealing with the other last point that Mr Lisak made on this ground, this has nothing to do with the change of circumstances. You can pick that up at paragraphs 26 and 27 of sparse shipping. Mr Phillips told the Court of Appeal there were some things that couldn't have been advanced. Mr Justice Popplewell, as your Lordship then was, he has an assertion, for example, that 40% of the shares in one of the relevant companies said to be owned by the appellants are in the names of Oceanus. And so he said that was all hiding the ownership. Then at 27, Lord Justice Longmore says this, but whether or not there are things that could not have been ventilated before Popplewell J, it seems to me irrelevant in the light of the width of 5293. As Vos LG says, it may be that it warrants the attention of the Rules Committee, but as I have said, the arguments are not all one way, because if there is a general power to impose conditions after permission to appeal has been granted, even if there is the restraint in 5292 that there must be a compelling reason to do so, this court is likely to be asked to entertain frequent applications of the kind that have been made in this case. Much money and time will be used up in doing so. Just pausing there, in my respectful submission, bearing in mind this is an extempore judgment, it might be clearer if in fact in that sentence what Lord Justice Longmore had said is if there were a general power. Because what his lordship is saying there when he says it's not all one way is that it's not all one way the arguments that this rule is silly. It's not all one way the arguments that this rule ought to be revised by the Rules Committee. What it's effectively saying is there are perfectly good arguments for having this apparently blanket, harsh rule. And the rules are policy rules, as he's already indicated earlier. That's what he's saying about it not all being one way. At 30, Malone expressly relies on this. The learned Lord Justice says there is some conflict in the authorities, but with respect, he is not suggesting that there's a conflict in the authorities on 18.3. He says nothing at all to support the idea that there's a conflict in that regard.
You're saying, therefore, that the rule itself is it says what it says on the tin.
Yes.
That's it. And if there are circumstances which arise during the appeal or pending the appeal, but after permission has been granted, then it would be under those general case management powers that you would apply.
My lady, you certainly could apply. Whether in fact there will be an argument that those general case management powers ought to be read down by 52.18.3 is another question. I would submit they would, but I don't need to make submissions on that point at all today because, of course, my own friend isn't going there.
No.
What you see in the authorities is various ways in which the courts have managed to use either the case management powers or another part of 52.18, specifically 1A, to achieve what they considered was just in the outcome. What nobody has done is said we can drive a coach and horses through the bar in 52.18.3. That's the point. And so that's why it's important that Malone & Friends application is predicated and made expressly on this extremely narrow basis. That's why the only thing we need to consider is how the court has considered that rule. Morris, my lady, I can take you to quickly. I think the decision of Mr Justice McComb, you can see from paragraph 9.
Sorry, where is this?
Sorry, this is Authorities Bundle 25, page 25. It starts at 24, and I'm going to 26.
So this is Morris, yes?
Yes, Morris, a decision of Lord Justice McComb. At paragraph 9, you can see it's the about 4 lines down. Mr. Morris, this is the respondent, it says, secondly, he made an application that the appellant's notice be struck out, alternatively stayed, in the event that the appellant did not pay either to him or into court the sums owing pursuant to the default judgment. There were 3 other applications made, but that's the only one we need to concern ourselves with. And you can see, I should have pointed out, that paragraph 7, that in fact, counsel, Mr. Roger, for the respondent, Mr. Morris, was present when Lord Justice Lindblom gave permission to appeal. That's paragraph 7. he said he was only on a watching brief, paragraph 8, but he certainly was present. Now, Lord Justice Picken picks up sparse shipping at paragraph 20. I should point out he's starting to deal with this second aspect of the case at paragraph 18. This is the relevant point. At paragraph 20, he deals with sparse shipping and points out that Lord Justice Longmore expressed the view that the rule didn't preclude an application under paragraph A, which we all accept. He then quotes over the page at paragraph 30 an extract from the White Book, but he somewhat reads that down and says that sparse shipping doesn't go anything like as far as the White Book editors would have us believe at 22. With the greatest of respect, I would respectfully submit actually the White Book is accurate in that regard, but it doesn't really matter for present purposes. At paragraph 24, you can pick it up. The judge says this: it seems to me that in imposing the restriction that it does in 52.9.3 of the rules, the rulemaking body has expressly excluded the power under A. Seems to me it's excluded for very good reason. Of course, at the permission stage, things are fresh in the Court of Appeal. The question of imposing conditions, paragraph C, may well arise, but as time goes on, the Court must retain, in my view, a power of control over proceedings before it, and if an appropriate case is brought before it, Mr Kern recognises there sometimes is, there must be a power to strike out. And the strikeout power must always include, as Mr Rogers submits, the power to order a strikeout unless something is to be done. That's paragraph A. Strikeout is A. I also recognise, paragraph 25, what Lord Justice Longmore said in the nature of the two cases that he had to decide, that's sparse shipping, that the exercise of a power such as is now invoked is a draconian one and can only be exercised as we all know in compelling circumstances. I've been directed to authorities by Mr Rogers on the question of compelling circumstances, and then he goes on to deal with Hammond and Merchant. But it's all about strikeout. He finds there is a compelling reason, but again, it's done under paragraph 59.1a, as it then was. You see that from paragraph 28. The next authority in the respondent's bundle is SpiceJet, starting at page 33. You can see, just to pick up what happened from the first two paragraphs, Lord Justice Phillips, who was sitting with Lord Justice Newgee, pointed out there was a first instance judgment of about $43 million, that's paragraph 1, and he directed that £5 million be paid into court, otherwise it would be struck out without further order. So it's a conditional strikeout, it's a 1A case again. But look what his lordship says at 14. At paragraph 14, as the respondent was present and represented at the hearing on the 23rd of February when the judge granted permission to appeal and did not ask that conditions be imposed, unlike here where they did ask for conditions to be imposed when the judge gave permission, it was clearly debarred by 52.18.3 from asking this court to impose a condition under 52.18.1c. It couldn't be clearer again. Nevertheless, de Havilland invited the court to strike out under 52.1a. That's not the course Mr Lissack is taking. If you look at paragraph 20 over the page, in my judgment, while the Court of Appeal undoubtedly retains jurisdiction to make an order under 1a, which effectively imposes a condition which could not be imposed under 1c, the discretion to make such an order must be exercised with some care. He's basically saying if we're trying to step round the bar and use 1a, you've got to be very careful. It's not just compelling reasons now. Some care with regard to the important policy considerations underlying the restriction imposed by 3 as identified by Lord Justice Longmore in sparse shipping. It's not appropriate to identify the precise circumstances in which that discretion might be exercised for obvious reasons, but I expect that in most cases the court would require there to have been a material change in circumstances since the hearing in which permission to appeal was granted, such as to justify reopening the matter at a further hearing, if you are using the strikeout rule. The last case chronologically is Hotel Portfolio, decision of Lord Justice Mayles 2 years ago at page 43 of the bundle. Paragraph 3. counsel for Mr Stevens takes a preliminary jurisdictional point that because the respondent was present at the hearing before the judge at which permission to appeal was given, there can be no order that the court exercise its powers under paragraphs B or C. Mr Pickering, KC for the respondent, accepts that, but submits that the application can be made under paragraph A. Mr Pickering, not as bold as Mr Lissack in that regard. Paragraph 10, can I just show you paragraph 10 because it will save me having to come back to this authority later. Just on, this actually deals with compelling reasons, which I'm not actually dealing with now, but it's relevant to pick it up now. Before any question of stifling arises, it remains necessary to consider whether there are compelling reasons to make any order. And the reason I make this point is that when I come to deal with compelling reasons, I'm going to avoid, for reasons I'll explain, any question about ability to pay and stifling. In my submission, they don't fall within the grounds which you need to consider as compelling reasons. They cannot be compelling reasons, and I'll show you why I say that. And for that reason, and I thought I'd agree this, or we'd agree this with Mr Lissack, I'm not going to be referring to anything Ms Walker says, any findings of Mr Justice Picken, nothing about the financial ability or inability of my client to pay the judgment sum. Now, my friend made various references to Ms Walker's statement. I thought we'd agreed not to, but I'm not going to take a point on that. I'm not going to. Now look at just one of my learned friend's authorities first in his second bundle. So that's Auth 2/13. This is the ex parte medical justice case. This is unique in the run of cases. Well, it's unusual in the run of cases for being a reserved judgment. And it is unique in being an application where it was the appellant who was applying to have conditions varied, as opposed to the respondent. You can see that from paragraphs 6 and 7. The Secretary of State, who was the appellant, was obviously present at the hearing when permission was granted, but nevertheless sought to vary the conditions. You can pick it up in the Master of the Rolls judgment at paragraph 13. What's useful about this piece is the Master of the Rolls bringing into play Section 54(4) of the Access to Justice Act. He says this: where a party seeks permission to appeal from the judge and is granted such permission on terms, I find it very hard to see how the terms could be appealed in the light of the substantive part of Section 54(4). There is in such a case a single, albeit in a sense composite, decision to grant permission to appeal, and any attempt to appeal that decision appears to me to be pretty clearly prohibited by the section. I have difficulty with the notion that an appeal against part of a single or composite decision could be entertained. Either decision is appealable or it's not. Section 54(4) says that it's not. As for 5291C, and we're back in the old rules, it seems to me that it gives the appeal court the power to vary the terms on which permission has been given, and it applies to cases where permission has been given by the judge as well as to cases where the permission has been given by the appeal court, which puts pay to the suggestion in Society Aram. However, 5293 provides that 5291C can only be invoked by a party who was not present at the hearing where the terms were imposed. That appears to be intended to tie in with Section 54(4). If a party who had attended the hearing before the judge in which permission to appeal had been given on terms could apply to the appeal court for a variation of those terms, the rule would at least conflict with the spirit of the statutory provision, that the application would really amount to an appeal. So it's a further underpinning of the basis for the rule that the Master of the Rolls is offering here. Now, I'll just point out at paragraph 22 that after His Lordship had considered Society Aram, he expressly says in 22 that that in Society Aram, sorry, it's the final sentence. The court. I'm sorry, I'm probably got the wrong paragraph. I'm sorry, it's going to be online offences, last paragraph 24. Yeah, I think there's something else. Sorry, yes, it is 22. I apologise, I went straight past it. In my view, the case of Society Aram and King should not be followed, as Section 54(4) was not cited and no consideration was given to the point that prospective appellant would have access to the Court of Appeal through making a fresh application for permission to appeal. So Society Aram is expressly disapproved there. And for what it's worth, Lord Justice Reimer, at the very last page of this report, page 22 of your Lordship's bundle, if anything, goes further, because he says at 39, I can see no reason why, upon the ordinary interpretation of the language of 52.9, paragraph 1c does not purportedly extend to the variation of conditions imposed by the lower court as much as the variations of conditions that the appeal court itself imposed when given permission to appeal. That's the Society Aram point. In the present case, however, the appellant is precluded by para 3 from making an application under para 1c. If she were not so precluded because she'd not been present at the permission hearing, there would, in my view, if 1c has the breadth of range I've suggested, then be a question as to whether it is to any extent ultra vires as purportedly conferring a right of appeal precluded by 54.4. So Lord Justice Reimer, if he was on the Rules Committee, would suggest that the rule ought to be extended rather than removed or curtailed or qualified. But whatever, with respect to the views of Lord Justice Reimer, Mr Lissack or anyone else, the ambit of the rule as it stands is perfectly clear. Can I then turn, in my submission, those cases put the matter beyond argument, and I find it somewhat surprising that my learned friend is pressing the idea that this is my submission, that is in my submission, that's trying to curtail a rule when all we're doing is reading it. Can I pick up my learned friend's second skeleton argument? I just want to make a handful of points on this, and on this I might have to take you to a couple of other cases that he cites. Paragraph 5.1 of my learned friend's skeleton argument on page 2. My learned friend uses the typically elegant language of calling this exquisitely fact-sensitive. I think that's his words rather than any court's words. But with respect, this point is not fact-sensitive. This point is a pure point of law. He then says at 5.2 there's some tension in the authority. That, as I've just demonstrated to your ladyship and lordships, is wrong. At paragraph 7.1, you don't need to go to Bell, because even Mr Lissack recognises that the case is irrelevant. At 7.1, he didn't read you the first bit, permission having been granted on the papers, the Bell predecessor provision was not strictly in issue. Quite right. Nothing to do with what your lordships and ladyship is being asked to consider. Paragraph 8 relies on contract facilities, but unless your ladyship and lordships want me to, I'm not going to descend to that case, because it is, I think everyone accepts, a case where the court was invited to and did use its case management powers. Again, it's nothing to the point. It was also a case which was sympathetic to, if not actually building upon, the Society Aram case, which, as I've shown you, was disapproved by the Master of the Rolls in medical justice. It does not say, contrary to what my learned friend seems to be saying sometimes, that 52.18 is simply some part of the case management toolbox. That's wrong. What it says is the court has general case management powers under CPR parts 2 and 3, which it can invoke, and it has the powers under 52. It's saying they are disjunctive and can be used separately. It's not saying one is subsumed under the other, which is the attempt, which is effectively what my learned friend's trying to say. Matani is the last case that's cited, and that's cited at paragraph 12.1 of my learned friend's skeleton argument, Matani and Sippi. It's a relatively old decision. What's interesting about this case, and I'm not going to take you to it unless you wish me to, but what's interesting about the case is that nobody cited this rule. Nobody cited subparagraph 3 at all. It reads from the judgment that it might well have been something which the court could have invoked. But this is, again, one of the problems with relying on purely extemporary decisions, often made under great time pressure when the Court of Appeal has better and more substantive arguments to hear. In this case, nobody refers to the Rule 3. It probably could have been invoked. But it's a 2013 decision, which from what I can tell, has never subsequently been cited in any of the run of cases that we've been looking at, and which didn't consider any of the relatively few earlier cases. And my submission, Atani simply doesn't take the point further because it doesn't talk to the point one way or the other. And that is the case which my learned friend puts up as being in tension with Hearst Holdings, which evidently is precisely on the point and says in terms that the rule says what it says on the tin, if I can adopt my lady's phraseology. I've left myself only, I think, 15, 16 minutes to deal with compelling reasons, and I apologise for going so fast, but I'm conscious of the time. But perhaps, unless your ladyship and lordship have any questions for me on the question of jurisdiction, I'll turn to compelling reasons.
You carry on.
My lady, the authority most usually cited in the modern era for what comprises compelling reasons is the decision of Mr Justice Christopher Clark in the Naftogas, Merchant International and Naftogas cases. My friend and I both think, except it's in his original authorities bundle, and the critical paragraph is 37, or I suppose 37 to 40, we don't need to go much further than that, but I do want to say one thing about Lord Justice Christopher Clark's sixth draft. If you pick it up at 37, the first 5 paragraphs of 37 seem to me, with the greatest respect to Lord Justice Christopher Clark, to be an accurate and comprehensive synthesis of the law up to that point, albeit maybe not utterly comprehensive. The essential question is whether or not there's a compelling reason to make the payment of the judgment sum plus costs and interest a condition of further pursuit of the appeal. B, whether there's a compelling reason is a value judgment to be made on the facts of the case. So far, so good. C, the fact that a judgment has been entered against the appellant and no stay has been sought or granted does not mean, as a matter of course, compliance with the judgment should be made a condition of appeal, nor does it alone afford a compelling reason for a payment order. But we're just pausing there. It's implicit in that paragraph that means that if a judgment has been ordered and not paid, that doesn't amount to a compelling reason, because it's talking about compliance. And there are many, many cases, in fact, probably all of these cases, where in fact the judgment sum had not been paid. That's kind of the premise of these applications. It's not enough on its own. D, on the contrary, the power of 52.9 was not designed to be no more than an alternative means of securing enforcement and is only to be exercised with caution. And then it's only really E, and I'll come to F momentarily, which actually descends to talk about the particular factors which might be taken into account. E, whilst every case depends on its particular facts, the court is likely to find there to be a compelling reason to make a security payment order which has the effect if the judgment debtor has in the past, which has that effect. If the judgment debtor has in the past, or is likely in the future, to take steps to denude itself of assets or to put its assets beyond the reach of the normal enforcement process. That's patently not our case, and I don't think Mr Lissack says it is. Can I, before we go further, just invite your lordships and ladyship to read 38 to 40 of Lord Justice Christopher Clark's judgment. I want to make some observations on it, if I may, but perhaps I can ask you to read it to yourselves. I'll just make these points, if I may. I should have said, firstly, this is one of those rare reserved decisions. This is a reserved decision of Lord Justice Christopher Clark. In my respectful submission, the summary which the learned Lord Justice draws at 40 that one of the reasons might be considerable practical difficulties in effecting execution needs a little bit of unpacking or needs qualifying. Insofar as it is based upon the 3 cases he cites, and it may really be 4 cases, as we'll see, the authorities go a little bit further, or the bar's a little bit higher. They are Hammond, Suddard, Bell Electric and Gold Trail. Before I go to that, just pick up, because it's right next to it, the quote, ordinary run of appeal category. That's the beginning of paragraph 38. That's a quote from Goldharp. If you go back to paragraph 35 of this judgment, you can see Lord Justice Rymer's dicta on that. This case falls within what I might call the ordinary run of appeals. The appellant is liable to an unsatisfied judgment debt if it is seeking to appeal in circumstances in which there's no stay of execution of that judgment. As I've said, it might well be thought that if there are no grounds for a stay, it ought to be a matter of course for the defendant to have to comply with the judgment of the court below as a condition of pursuing appeal. As I've said, I do not, however, understand that to be the law. Mr. Lissack is trying to suggest to you that that is or should be the law, but it isn't the law. Our case is an ordinary run case. Going back to paragraph 38 of NAFTO gas, Lord Justice Christopher Clark relied upon Hammond, Suddard, Bell Electric and Gold Trail, but in none of those cases was it merely a case of there being considerable practical difficulties of enforcement. I can do this relatively quickly because you can pick it up from what Lord Justice Christopher Clark himself said about those 3 cases. So if you go back to page 60 of this bundle, you can see the paragraphs from Hammond Suddard, which Lord Justice Christopher Clark thought relevant, and they start at paragraph 19. The appellant is an entity against whom it will be difficult to exercise the normal mechanisms of enforcement. But he goes on, the BVI company has no assets in the UK, but he goes on, this is Lord Justice Clark, goes on in 2 to say the appellant plainly either has the resources or has access to resources which enable it to instruct solicitors and counsel to prosecute the appeal. And pausing there, the reason it was relevant in that case is that the actual sum in question in Hammond, Suddard and Agrichem was the debt which hadn't been paid on a solicitor's bill. And it was, you can see from Hammond Suddard itself, a pretty modest sum. It was £76,000 and 465,000 Belgian francs, which you may or may not recall was about 50 or 60 to the pound. That's about 10,000 more pounds. So it was less than £100,000, and yet Agrichem was using leading counsel, solicitors and so on to prosecute the appeal. That's the relevance of the point there. It's not relevant now. I don't know Lord Wolfson's brief fee, but I can assure you that my brief fee doesn't come close to the judgment debt. Then, there's no convincing evidence, this is paragraph 3, that the appellant does not either have the resources or have access to resources which would enable it to pay the judgment debt and cost was ordered. It's failed to do so. And then the discovery which the appellant has provided of its financial affairs is inadequate and gives the court no confidence it's been shown anything near the truth. And then at paragraph, that's all I need to read on that. So it's not just difficulties of enforcement, it's basically, sorry, I should have read you, I do apologise, the very end of paragraph 1 again. Given the attitude of the appellant to date, including that demonstrated on these applications, it's fanciful to think the appellant will cooperate in the enforcement process. That's Hammond Suddard. Bell Electric, the appellant had made it very clear that it would take steps in Germany where it was resident to invite the German courts to put obstacles in the way of enforcement. That was the problem in Bell Electric. So what in fact, with respect, Lord Justice Christopher Clark is saying at 40 might be qualified by saying considerable practical difficulties which are created by the appellant itself, where it is putting obstacles in the way. Because it is obvious that there may well be cases where there are practical difficulties of enforcement against a defendant against whom you have judgment based in a country where enforcement involves complicated formal processes, but that isn't what Lord Justice Christopher Clark is referring to. He's talking about cases where the appellant puts obstacles in the way. One other point I want to take on the law before I move to the facts of our case which is a dicta from Cruz City and Unitech, Lady Justice Gloucester, paragraph 28.
Sorry, where do we find that?
So this is at page 64. All I'm doing is citing bits of
Yes.
Naftogas. This is Lord Justice Christopher Clark citing Lady Justice Gloucester
Cruz City,
in
yes.
Cruz City. It's paragraph 24 of her judgment, which I'm going to read right at the bottom of the page. It's clear that in similar situations to the present, i.e. in cases where judgment liability has been given that is no longer subject to appeal and the relevant appeal relates to subsequent enforcement orders or orders in aid of execution, courts at all levels have been prepared in appropriate circumstances to require an appellant to pay into court the amount of the judgment debt as a condition of the grant of appeal. Now, Lord Justice Christopher Clark makes that distinction in this case. He distinguishes the two situations in paragraph 41, page 70, by describing one as a liability appeal and the other as an execution appeal. And effectively what he says is that, although it doesn't matter in this case, execution appeals ought to be treated a little bit more harshly. You've already had a judgment, might be an arbitration award or a foreign judgment, but you are simply seeking as an appellant to oppose processes of enforcement. In Naftogas, it was the appointment of a receiver to recover a debt that had gone back to 1999, where there had been a judgment in 2011. In this case, it was 2016. This wasn't a liability appeal. In fact, in Lord Justice Christopher Clark's case, he said it made no difference because he was going to pose the condition anyway. And you can see that at paragraph 74, at G. This is just his final decision, his rationale for making the order he did. The fact that this is an execution appeal does not justify taking a different stance. If this was a liability appeal, there would be compelling reason to make the order. In an execution appeal where liability is a given, that is so a fortiori. We are not an a fortiori case. This is a run-of-the-mill case. So now understanding the law, can we consider Malone Friend's alleged compelling reasons? He set them out in his first skeleton argument from paragraphs 13 to 22, and following his oral submissions, I'll take them in the ranking that he said he put them in himself. So we start then, to find another scrap of paper that I wrote them on.
No question of stifling, number one.
Yes, no question of stifling, number one. Now, as I pointed out to you from Lord Justice Mails's decision, that question hasn't arisen yet. We're talking about compelling reasons. Stifling only arises if your ladyship and lordships is convinced there are compelling reasons. So his first basis for saying they're compelling reasons isn't a basis at all. Ignore that. His second one is number 3 in his list. VietJet has the means to pursue the appeal. The same point expressed in different ways. It's the same point as stifling. It's the obverse of the stifling point. So his first 2 points are irrelevant when you're considering compelling reasons. His third point is there might be difficulty enforcing. That's third in importance, first in the list. That's paragraph 13. VietJet has few assets in the UK. They're all in Vietnam. Well, qualified as I suggest it should be read, Lord Justice Christopher Clark doesn't suggest that a difficulty to enforce in a foreign country is of itself a problem. Now, but in any event, my lord, the respondents knew that my client was based in Vietnam. If they didn't pick it up from the name, they might have picked it up before they sued VietJet in 2022. It is a Vietnamese airline based in Vietnam, operating flights out of Vietnam. Where did they think its assets were going to be? The next basis, the next compelling reason Malone and Friends suggest is non-compliance with the orders. This is 14 to 17 in Malone and Friends' scheduled argument. Paragraphs 15 to 17 of that 4-paragraph section is all about the press. Nothing to do with compliance with orders. In fact, if you read Baker 1, and I don't encourage you to spend much time doing so, you will find a litany of complaints about interlocutory problems. Disclosure, provision of documents for the most part, all the way through the run of the case. There's nothing suggesting that there's been a contumelious failure to pay sums when ordered. the first and only occasion on which there was any breach by my client to pay a judgment debt was Friday. The sixth point was said to be the fifth most important. That's a campaign. I'm not sure where that fits into Lord Justice Christopher Clark's list. I appreciate it's not a statute, but it doesn't seem, with respect, to be a compelling reason on any basis at all. And the last point was that Mr Justice Picken intended, apparently, to make sure that the first tranche was payable as an incentive for VietJet to pay it before tomorrow. We cited in our skeleton argument why, in fact, that is a considerable over-reading of what Mr Justice Picken said in response to my own friend Mr Shah when he made that submission below. It's an extremely weak point. So, where does that leave us? In my respectful submission, there are no compelling reasons at all. The position is rather, as we put out in our skeleton argument, 4 main points here. Firstly, we have been given permission to appeal by the judge. It's an arguable appeal. He said, as we cited in our skeleton argument, this is a complex question on which the Court of Appeal might come to a different view. There is no evidence, and even my learned friend doesn't suggest this, that VietJet is in the course of dissipating its assets, or that it's going to do so. It's not a sort of quasi-freezing order situation where you're dealing with a shell company with shadowy owners who move assets around or only capitalise it for the purposes of the appeal. We are only 3 days late. 2 if you don't count the weekend. 4 if, 2 or 4, depending on whether you count the weekend.
So far.
So far. Tomorrow, 5, my lady. This is only a means of enforcing the judgment. And if you stand back, and I'll stop in 1 minute, you have to ask yourself, what is the point of this? Is it tactical skirmishing or not? My learned friend says this really is the last thing we need. Well, it was in his hands to decide whether he wanted to do it. But what are they seeking? They're not captors of the chronology. The chronology is such that shows that it's an utterly inappropriate application. The courts have said you ought to impose conditions only in compelling circumstances, where there are compelling reasons, and you ought to do it cautiously. The courts have said failure to pay a judgment debt is not enough of itself. The courts have said, then, you've got to make it in good time. The chronology demonstrates this is an application that should never have been made, even if it does have jurisdiction, because the actual trigger for it arose on Friday, and this appeal was starting on Tuesday. All costs have been incurred for this coming week. All the work has been done, I dare say, for the next 3 days. Your ladyship and your lordships are ready. Time has been booked out of everyone's diary who's sitting in this room, the bench, counsel, solicitors, everyone else. Actually, the respondents want tomorrow adjourned. That's what they want. They want it adjourned because they don't want to face the music. They don't want to face the Court of Appeal considering these evidently strong grounds of appeal. They don't want that, or they want the money paid in. This is nothing more than a tactic to try and secure the debt or put off the appeal. That's all it is. So for those reasons, my lady and my lords, I say there's no jurisdiction, and in any event, there are no compelling reasons. I'm not dealing with ciphering, as I've said.
Thank you. Mr. Lissac?
You've got 2 minutes.
Mm-hmm.
Can I make these 2 points? So this is a question of could and should. Could the rule be read in the way in which my learned friend reads it? We respectfully submit the answer to that question is no. For him to read it as an absolute bar upon this court's ability to impose conditionality in respect of circumstances that did not exist at the time permission was granted is a significant overreach. As regards case management powers, these are referenced in our skeleton argument, second skeleton, paragraphs 8-4. The should. The compelling reasons, this is not an ordinary run case, it is quite anything but. The history of this case is really, even by the context of hard-fought commercial litigation, quite extraordinary. We stand by our list of competing or compelling reasons. And the only 4 days late point, as my lady pointed out, Riley, so far, is really not the point at all. The one thing I agree with another friend on is things didn't crystallise until last Friday, insofar as debt is concerned, but that is as it may, just a function of the chronology in this case. And the other point I make, and then I'm done, inconvenience to the court, inconvenience to the parties, this is not to be taken lightly and is not taken lightly by us, I assure you. We too are ready to conduct this appeal. And then friend to suggest we're frightened of it in some ways is, frankly, with respect to him, unworthy as a submission. This is no tactic. This is a desire to try to ensure that the appropriate discipline is put upon VietJet insofar as the price for progressing this appeal is concerned. Those are our submissions.
Thank you very much indeed. We'll rise for a few moments.
Sorry. It's really panicky. I hate the first things. I have all those sorts of surprises.
You just don't know, yeah. It's like,
Oh, okay.
No, it's actually chosen. Okay.
No, absolutely. Absolutely. No, no, of course.
David, sorry to interrupt. Do you want me to mention something about our seating arrangements staying? You
Well,
said-
yeah, why don't you? Yeah, because
Okay.
I mean, it might just be easier to stay. Do you want to stay here, or because we've all logged in? What do you think? Okay. I mean, of course, people don't mind. It might just be easier,
Yeah, sure.
unless you want me to ask. I mean,
No, I don't
but
mind.
you're on your feet anyway. So.
Yeah, sure. Certainly.
I mean, they know who's the appellant.
Do you think they've spotted that?
I don't know.
You reckon?
Maybe.
Shall I just make that submission?
Maybe your written argument is so good that they think you're appealing.
Well, after the summary of the appeal by Stephen,
Yeah.
Yeah, well, you probably want to be a parent, don't you?
I would love to.
Yeah.
Okay, I'll mention something.
I did do one appeal, it must be now 20 years ago, where I won before the judge on such terrible ground. It was a terrible judgment. But in the Court of Appeal, they said to my opponents, well, we'll hear from Mr Wilson first. And I was the respondent. But the judge was such a warning for me.
I did a case against Laurie not very long ago where we won first instance, and they were applying for permission to appeal to the judge in the usual way. And I opposed it. And Laurie preempted what I say by me having the luxury of being able to say how wise and right you are. Something that he didn't feel able to do.
That's very good.
Yeah.
That's very good.
Are you going to start with 2? As long as you don't start with 4.
That might have to be
No, I think so.
if you want.
Yeah.
I can deal with that. It can only be part of you to do. That's a
Fine.
I don't think
All right.
Thank you very much for all of your submissions and for the preparation which has been done in a very short space of time. The application is refused. Reasons will be given at the appropriate time rather than now. And therefore we look forward to seeing you in the morning. 2 things we'd be grateful for. One, confirmation that we will receive the transcript both of today and as the appeal proceeds. Thank you. And perhaps, I don't know, if we're going to have a rolling transcript, I'd be grateful if we could therefore have username and password. I don't know whether we are or we aren't. It is very useful, but there we go. And also, there was a flowchart, I think, at the back of Mr Justice Picken's judgment about the questions and how they interconnected. And I don't think that is, well, we haven't found it in the bundles and we'd be very grateful for it. I'm sure that can be obtained from somewhere.
My lady, I'm sure it can. So, my learned friend Lord Wilson nodding. May I please say 4 things in response? 1, and I repeat what I opened with, which is to thank each member of the court and all those behind you for all of the work you've been kind enough to do in accommodating this refused application. And we don't underestimate the extra burden it places on the court, which I'm very grateful to the court for finding time to discharge. Secondly, as regards to the transcript, I can tell you will have the ruling transcript tomorrow because that was something you pre-approved, and it was just today the approval got lost in the system. Thirdly, a tiny point, but may we have your permission to remain orientated like this, because we've logged in on various sides to some of the Opus computers that are provided. Well, they're with the wrong way around because they're the appellants. Do you mind if we stay this way around?
I certainly don't mind at all. No, there's no need to try to rewire everything.
Thank you very much indeed. And fourth and last, we look forward to seeing your ladyship and your lordships in the morning.
Thank you very much.
My lady, my lord, I don't want to end on a controversial note, but we would be making an application for the cost of today. But what we would propose with respect, if this is convenient for the court, is to make that application once we've seen the court's reasons and when we're dealing with the cost of the substantive appeal as well, if that's convenient, but just to put a marker down, if I may.
I think that is the most economical and sensible way of dealing with that, and it will arise down the line.
Yes.
And in terms of drawing up an order, speaking entirely for myself, it seems sensible that that can also await our giving our reasons.
My lord, my lady, yes.
Yes. Thank you very much.
Thank you.